Good morning, Ms. Hofmeyer. Good morning, everybody.
Good morning, Chair.
Are we ready?
We are indeed. Chair, Mr. Mkiwa will be presenting the evidence of today's witness, Mr. Human, but there are a few procedural aspects I'd just like to deal with at the outset of today, with your leave.
Yes.
Chair, since yesterday, we received 3 responses from implicated persons to the evidence of Mr. Human, and I indicated earlier in the week we would update you as and when that occurred. Chair, they are responses from Ms. Kwinana, Ms. Mamela, and Swissport, South Africa. And I'll deal with each of them in a little bit more detail in a moment. But there was an issue that was raised in the course of the hearings yesterday about the process for Rule 33 notices and the types of responses that are received from implicated persons. And the question that was raised with us was, is it adequate that the response from the implicated person come on as a statement as opposed to an affidavit deposed to under oath? Chair, we looked at the various provisions of the rules, and we have also considered the practice that has been followed by the Commission to date. I'd like to address just both of them. The rules themselves, in Rule 3.3, which is the rule that requires notice to be given to implicated persons, is a rule that requires the legal team to give notice to implicated persons when they intend to present to the Commission a witness whose evidence implicates or may implicate that person. And then what Rule 3.4 says, I should just add before I go on, that notice identifies for implicated persons that they have certain rights, and then they can also seek leave to do certain things. The rights are to attend at the hearing and to have legal assistance. The opportunity offered, subject to your leave, is to present evidence themselves, to bring the evidence of another person, or to cross-examine the witness. Now, what 3.4 then says, Rule 3.4, is that an application in terms of Rule 3.3, that is an application to do one of those 3 things, must be submitted in writing to the Secretary of the Commission within 14 calendar days from the date of the notice referred to in Rule 3.3. And it goes on to read, the application must be accompanied by a statement from the implicated person responding to the witness's statement insofar as it implicates him or her, and the statement must make it clear what parts of the witness's statement are disputed or denied and the grounds upon which those parts are disputed or denied. Chair, the Rule 3.3 notices that are sent out by the legal team of the Commission replicate this language from Rule 3.4. And so, in other words, what that notice does is it alerts the implicated person that in order to respond and to make such application, they must do so in writing, accompanied, an application in writing accompanied by a statement. Chair, it is our submission today that insofar as implicated persons have previously received notices in respect of which they have been told that they must provide a statement as opposed to an affidavit deposed to under oath, it would be appropriate that those statements be received, and where it is useful because they've received in advance of a witness's evidence, to then use the opportunity in the hearing to put that version, albeit on statement, to the witness for comment. Chair, it may well be, you raised in the course of the debate yesterday with my learned friend, that there is that catch-all general provision in the rules, that is Rule 11, that talks about whenever the rules, this is 11.3, whenever the rules make provision for a person to apply to the Commission or the chairperson, the application must be a substantive application on affidavit with a notice of motion. Chair, it may be that going forward, it would be appropriate, it is our submission, for some revision to be made to the Rule 3.3 notices that go out to make it clear that there any application in terms of 3.4 should nonetheless be on affidavit, because then, I think as you were highlighting, yes, at least you have a deposed to version and a witness's version under oath. But it would be our submission for today's purposes, and given the practice that has been followed previously, that the Commission acknowledges that it has received statements from implicated persons, and where relevant, that those statements be put in the course of Mr. Human's evidence today. But before I go there, I would just like to make one further point in relation to the specific applications that have been received in relation to Mr. Human. Because even if there was a remaining concern on your part about a version not under oath and a version under oath, it actually doesn't arise in today's case, and I'd like to explain why. The first application, or at least the first statement received, is not an application to cross-examine Mr. Human. It is a statement received by Ms. Kwinana in response to Mr. Human's affidavit. Now, Ms. Kwinana deals briefly with some of the aspects. It's our proposal that we put those points, where relevant to the matters that we will be focusing on today, to Mr. Human. But I also think it's necessary to indicate that it is the intention of the legal team of the Commission, certainly in due course, to present the evidence of Ms. Kwinana in these hearings. And I can indicate to you, Chair, that we are engaged with her at the moment about meeting with her and facilitating that. So in that respect, there should be no risk of a situation where you have a version from her not under oath and a version from Mr. Human under oath. Chair, the same applies in relation to Ms. Mamela. Ms. Mamela does bring an application to cross-examine Mr. Human, but Ms. Mamela has been summoned to appear tomorrow. And depending on what happens in relation to any application she may bring, it's certainly the intention that her version also be provided to this Commission under oath. And so we advance in our submission the interchange between her and the disputed versions by putting them first to Mr. Human and then addressing them tomorrow with her in her evidence. Chair, the final response was a response from Swissport South Africa. Now, Swissport South Africa has indicated that it is still in the process of considering Mr. Human's affidavit, but they have drawn the Commission's attention to the fact that the former CEO of Swissport South Africa, Mr. Cole, who's not currently present in South Africa, I think he's now working for them in the United States, has supplied an affidavit to the Commission in the course of its investigations. I think we received it last week. And so all that they've done is that they've highlighted the parts of their affidavit previously supplied, which they say are a response to Mr. Human's evidence. And so it's on that basis that we propose to put their responses. I should also just note that their correspondence with the Commission yesterday indicated that they will continue to consider his affidavit. They've not completed doing so yet. And if necessary, they will apply to supplement Mr. Cole's first affidavit if they deem it necessary. Chair, with that background in place, we propose along the lines that I've described to conduct the proceedings today.
No, that's fine. The one aspect that I want to raise with regard to the issue of statements that are not under oath or that are not affirmed is whether some of the statements you have received, such as maybe from Ms. Mamela and Ms. Kwinana, and maybe from any implicated person that may have responded to 3.3 notices before, whether it's simply a statement it's simply a statement that is not an application for leave to adduce evidence or for leave to cross-examine. Because there may be an argument that 11.3 maybe doesn't apply to a situation where somebody does not apply for leave to adduce evidence or to cross-examine or to call witnesses, but simply says, here is my side of the story. What you do with it is up to you.
Indeed.
So to the extent that that might be the position, it may be necessary that the rules be amended, because I think that when a witness has taken the trouble to go under oath in regard to what they tell the commission, anybody who wants to challenge their evidence should take the same trouble and also go under oath.
Indeed.
And we shouldn't have a situation where the witness has gone to the trouble of going under oath and somebody just sends us a letter or just a statement where there would be no consequences if what is contained there is not true. You know? So we might need to amend the rules to cover that situation. Indeed. But all those implicated persons who have responded in the past and may continue to respond in the future to 3-3 notices that don't call upon them to put their statements on affidavit, those will be accepted and be dealt with.
Yes.
On the understanding that it's the 3-3 notices that didn't require them to put that under oath. But once the 3-3 notices have been amended, then everybody would need to make sure that their statements are under oath. Indeed. So at least I think it's important that we have cleared it, because it arose yesterday.
Indeed, Chair. Just on the factual question as to the ones that we've received in relation to this evidence, the only cross-examination applications are the ones from Ms. Mamela in respect of Ms. Sambo yesterday and in respect of Mr. Human. The rest are just statements in response. Or in the case of Mr. Cole, an affidavit previously provided in response. But given that Ms. Mamela has been summoned to testify tomorrow, it seems to me we can address those aspects given that she will be going under oath.
Yeah, that's fine.
Thank you, Chair.
Okay, thank you.
I'll hand over to Mr. Mbikiwa.
Okay, thank you. Mr. Mbikiwa.
Good morning, Chair.
Good morning.
Chair, could I just have a moment to get my files? Thank you, Chair.
Thank you.
Chair, are we ready to proceed with the witness?
Yes, please administer the oath of affirmation.
Please state your full names for the record.
Skalke Hendrik Human.
Do you have any objection to taking the prescribed oath?
No objection.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence will give will be the truth, the whole truth and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may proceed.
Thank you, Chair. Chair, may I ask that the files labelled, the files containing Mr. Human's affidavit and annexes be admitted as exhibits DD22A to DD22G.
B up to G, are they there?
They should be, Chair.
Okay. Are they all annexes to his statement?
They're all annexes to his statement with a small section in G for additional documents such as the statements that we've received in response.
G.
In G.
Up to F, it's annexes to his statement.
And including most of G is annexed.
Including most of G.
Indeed.
Okay. The file containing Mr. Skalk Hendrik Human's affidavit will be marked Exhibit DD DD22A, together with the annexures contained in that file. The other files marked Exhibit DD22B to G contain annexures to his affidavit, and they will be marked accordingly. But it's recorded that G, that is DD2G, contains not only his annexures but also other documents. Yeah.
Thank you, Chair. Mr. Human, can I ask you to open the file that should be in front of you labeled DD22A? Can I ask you to turn to the first page? And you'll see the red numbers in the top right-hand corner. Those are the page numbers that I'll be referring you to during the course of your evidence. We will, for the most part, be within this file, but during the course of your evidence, I will take you to other documents in the files that should be alongside you. Can I ask you to turn to page 54? Is this the affidavit that you provided to the Commission?
That is correct.
And is that your signature?
Yes, it is.
And do you swear that the contents of the affidavit are true and correct?
I do.
Thank you. Mr. Human, your affidavit deals in some detail with a variety of issues and the full chronology of events. And it's not necessary for us to traverse most of those matters, subject to the Chair's direction, both because much of it is uncontentious background material, and also because much of it was dealt with by yesterday's witness, Ms. Sambo. Instead, I intend to take you to particular aspects where your expertise and experience will help to shed some light on the process. Can you begin by telling us about your qualifications?
Yes, sir. I hold a bachelor's degree and a diploma in financial and administration, public financial management and administration.
And what is your employment history?
I was employed at the Auditor General for 10 years, thereafter joined the National Treasury, in the Office of the Accountant General for 5 years, thereafter in the Office of the Chief Procurement Officer, and served as the Acting Chief Procurement Officer for 18 months odd under Minister Gordon and Nene respectively.
And tell us something about what that role involved.
The Chief Procurement Office is responsible for the legal and regulatory framework in public sector procurement. It's responsible for the governance of those processes, and it's responsible to ensure that transversal contracts applicable to the whole of government are tendered, evaluated, and adjudicated. The office manages approximately 80 billion rand of transversal tenders.
And what position do you currently hold?
I'm currently the acting head of department in the technical materials department at SAA Technical, responsible for procurement, logistics, warehouse and storage, and inventory management.
And can you tell us what South African Airways Technical is and what it does?
South African Technical is a state-owned company charged with the responsibility of maintaining aircraft. Its main customer is SAA, and it's also 100% owned by SAA. It specializes in maintenance, repair, and overall activities, scheduled maintenance, as well as unscheduled maintenance, and it serves a number of customers. The main customer is South African Airways, but we also have a healthy portfolio of third-party customers like Mango, Comair, and a few other airlines like Air Namibia to name a few.
Now, Mr. Human, you've spoken in your affidavit about the approach you've taken to your evidence, and in particular those issues that you do and don't have personal knowledge of. Can you give us an overview of what approach you've taken to putting together a chronology of events?
Absolutely. Chair, I was not employed at SAAT at the time of the award of these tenders. I started my employment on the 25th of July 2018, and my approach was in compiling this affidavit to base these statements on written documentation available to me, the content of forensic reports, and the minutes of the procurement and board committees. My approach was to capture the sequence and chronology of events based on these documents and reports.
Thank you. Can we then move to components tenders? And we can pick that up at your affidavit on page 5. Can you explain, broadly speaking, what a contract for the provision of component support services is?
Certainly. Chairperson, in the maintenance of aircraft is quite expensive. So to hold excessive stock, especially of what we call rotable components, is quite expensive. Very few airlines in the world has the capital means or the monetary means to buy excessive stock. So a pool contract or a component contract is where inventory would be centralized by a service provider, and those who would like to use this service pay a premium on a monthly basis, usually a flight hour rate. That's every hour that the aircraft flies, a specific agreed upon rate would be paid for the use of components. The benefit for a maintenance and repair organization is that if there's a failure on a component, you have the benefit to access a replacement part quite quickly, within days. While if you send it for a repair, it might take up to 3 months or even longer, depending on the complexity. So participating in a pool contract provides the opportunity to have spares available so that aircraft are serviceable and available to be deployed into service. There is usually 3 components. Chair, I've interrupted you, I think.
No, continue. I'll ask you after you are done.
Okay. There's usually 3 components. A base kit, that is a list of core components that the service provider would put on site on the premises of the organization so that you can access it within hours. The second would be advance exchange service. One would request a specific part. It will be shipped to your premises, and you have to return a core unit, the unserviceable one, the one that is out of service. The third aspect is repair services. When you have a component that has become unserviceable, it's sent to a repair shop of the supplier, and once it's repaired, it will be returned to the organization.
Did you say this is a pool arrangement?
Yes, sir.
Does that mean that there would be a supplier, and this supplier would have arrangements or contracts with different airlines, for example, or companies, and they all look to this supplier for parts whenever a need arises, and the obligation of the supplier is to always have the parts that may be needed by the companies that have contracts with them. Is that right?
That's correct, Chairperson.
Yes, and you say an airline wouldn't like to keep its own stock because that's very expensive.
Hundreds of millions of rand worth of stock.
Okay, thank you.
And just explain for us how the pricing works. We heard from Ms. Sambo yesterday a reference to PBH, or I think she said it was power by the hour. Just explain what that is.
That's correct. Power by the hour is a generally recognized term in the industry, and that's a rate agreed between the supplier and the recipient, in this case SAAT, on how much you would pay in dollars for every hour the aircraft flies. The incentive is there's no revenue when the aircraft is on the ground. So the incentive is on the supplier to make sure that quality components are delivered quite fast. It's dispatched within very short space of time so that it enable revenue generating flight hours. The rate is usually determined with a couple of elements. It will be the pool access amount. There's a provision made for beyond economic repair. Chair, it happens that spares just come to the end of life, and even if it's possible to repair, the cost thereof will well exceed the economic value thereof. So instead of replacing the full fair market value, it's almost like insurance that you pay, and in case it fails, only a percentage would be applicable.
I guess that it happens, but very rarely, that a part that hasn't come to the end of its life just falls from the sky as the aeroplane flies. I had something like that recently.
No comment, Chair.
Yes.
Chair, in rarest of occasions, this might have happened before.
Yes.
Mr. Human, can you tell us something about the procurement process within SAA Technical and the stages that need to be followed in order for a components contract to be entered into?
Absolutely. As a state-owned company, we fall within the ambit of the provisions of the Public Finance Management Act as a Schedule 2 entity. The Act provides for differentiation between departments, municipalities, Schedule 3A and C entities, and then big entities like SAA, Transnet, Eskom. It's based on the principles of the Constitution in Section 217, that all procurement should be open, fair, transparent, equitable, and cost-effective. Those are the principles that has also been adopted in the supply chain policy of the group and of the companies that it owns. The policy therefore provides that tenders or acquisitions, sourcing, should happen by advertising bids on its website, on the Treasury's e-tender portal, or in the state's tender bulletin. It allows for a minimum number of days, obviously to allow a fair chance for suppliers to prepare a quality, responsive bid, and such a publication is based on a so-called request for proposal or a request for bid, and this document specifies the critical criteria. It's really articulating the needs of the organization and discloses how scoring in this manner will be done. The policy further states that there should be segregation of duty, and by that I mean that those who are charged in compiling the specifications for such a bid should not be the persons that's also responsible for the evaluation thereof, The rationale is basically that one doesn't design a tender for your own interest and for specific buyers for a product. The third compulsory committee is a bid adjudication committee, and also in this case the members are not the same, with the intent that there is segregation of duty. As an extra governance measure, the policy provides for a delegation of authority. It's threshold driven, it's based on values of tender, where high value tenders are referred to the board, the relevant board. In this case it will be South African Airways Technical Board for final approval. The process will then, upon award, result in the finalization of a contract, stipulating the conditions that was advertised. Typically a service level agreement depicting performance aspects would be included, and then the process will progress to contract management and supplier performance.
And within that process, where does the cross-functional sourcing team fit?
During 2016, the SAA and SAAT policies also provided for a so-called cross-functional sourcing team. And in the case of SAAT, this group of people were responsible for both compiling the specification as well as conducting the evaluation. In 2016, the National Treasury issued Instruction 3 of 2016 specifying the segregation of duty in no uncertain terms, and from there on this is practice that the three committees is the legitimate committees in procurement to address the process required.
So the CFST is a 2016 and before phenomenon?
Yes.
Thank you. Mr. Human, you list in your affidavit 5 tenders that you then deal with. For the reasons I've given, I don't intend to spend much time on most of those. But just tell us, before the first tender was issued in February 2013, who was the provider of component support services?
Air France.
And can we go to the first tender? You deal with that from paragraph 29 on page 8 of your affidavit. What was the recommendation of the CFST in this tender?
I'm sorry. Can I first hear what the tender was about?
Yes, certainly.
If you have covered that, I must have missed it. Then if I can hear what the tender was about first.
Chairperson, a component tender for SAAT was advertised 5 times consecutively. The first occurrence of this bid was on the
Hang on. Is that the one I heard about yesterday?
Sorry, Chair?
Is it the same tender I heard about yesterday?
The first one is the first one that...
from Ms. Sambo.
From Ms. Sambo, indeed.
So, and when he talks about advertised 5 times, he's talking about exactly that one.
Indeed.
We said is the same, but...
Indeed, Chair.
Yeah.
And on each occasion, it had a separate bid number. So it was re-advertised under a new bid number. So we have been referring to it as the first, second...
Yes. Okay, now, Mr. Human, you don't have to go through that. I now understand. It's something that was dealt with yesterday. But it was a components tender.
Correct, sir.
Yes, okay, thank you. Mr. Mbigwa, you had asked a question about cross-section or something.
Yes, I was just asking what the recommendation was in that by the CFST in that tender.
Well, I'm sorry, Mr. Human, you might not understand this, but maybe for purposes of consistency, we may have to refer to them as first, second, third, fourth tender, as we did yesterday.
Yes.
Because
Okay, sir.
your evidence has to link to yesterday's
Yes.
evidence so that it's clear we talk about the same thing.
Absolutely.
Okay, so this is the first tender.
Chairperson, the first tender was advertised, and the recommendation by the cross-functional sourcing team recommended that the component support for the Boeing fleet be awarded to Israel Aerospace, or IAI is the abbreviation commonly used, and for the Airbus fleet to Air France.
And what was the outcome of that tender?
The outcome was that eventually the board approved that this tender be retracted in totality, that SAAT test the market by requesting quotations from other parties to test the relevance of pricing, and then to allow SAAT to deviate from a competitive open tender process and rather confine the award to only one bid. Chair, I have tried to depict these facts in paragraph 41 of the affidavit.
Before we get there, and this may be because of the way we're naming the tenders, but at paragraph 41 of the affidavit, you're talking about tender SP 43714, which is what we might refer to as the second tender.
Yeah. So his question, Mr. Human, related to the first, what we call the first tender.
Oh, yes.
Yes.
Chair, I apologize. The first tender was numbered in terms of the tender registered SAAT as SP 401 of the 2012, the first tender. If I may confirm, the CSFT recommended the award for the Boeing fleet to Israel Aerospace and for the Airbus fleet to Air France.
Yes, okay.
And then the recommendation from the board.
You deal with the BAC recommendation at paragraph 33.
Yes. The recommendation was in paragraph 33, and I've attached as an annex a copy of the BAC resolution, that it should be cancelled and retracted to allow an integrated approach.
And what does that mean, an integrated approach?
Integrated approach would mean that the services for components and for logistics be combined in one tender and one award.
Thank you. And so now we can...
I'm sorry, key integrated approach is?
So the two big ticket items in terms of cost drivers at SAAT is the cost of the component itself, but also the transportation. Most of these are flown from either America for Boeing parts or Europe for Airbus,
Yes.
and represent significant amounts of money. So integration was the supply of the components plus the transportation or logistics thereof.
Also that the bid mustn't disregard transport costs and only add them later when they've got the tender.
Correct, Chairperson. It's a concentration of spend of two cost
Yes.
drivers into one very big
Okay.
tender.
Okay.
Thank you. Mr. Human, we can now move on to the second tender, SP 43714.
Correct.
I'm sorry. So what you said earlier on, namely the board decided that the tender be confined to one supplier, that related to the second tender, not the first.
That's correct,
Okay.
Chairperson, and I do apologize for...
Okay, all right, thank you.
Mr. Human, sorry, Chair.
Yes, no, I'm wondering whether your approach is to let him say something on each one of them before you take each one in terms of how far it went ultimately, or whether you would be saying, okay, let's finish with the first tender, or maybe confused because there was a withdrawal, so the second tender arose because there was a withdrawal of the first tender. Okay, so there would have been nothing done after. Yeah.
That's right,
Okay.
Chair.
Okay.
That's the
All right.
chronology.
Thank you.
And you've told us what happened with the second tender. What was your understanding of the reason for the retraction?
So I just want to confirm we are now on tender 2.
Now we're now on tender 2.
Okay.
Yes, but I think that question, and Mr. Mbigiwa is going to explain if I misunderstand him, I think that question goes back to the first tender to say, what was your understanding of why that tender was withdrawn or retracted?
No, Chair, let me
I
try and
misunderstood you.
clarify.
Okay.
Mr. Human thought I was talking about the second tender when in fact I was talking about the first.
Yes.
And explained what he had said at paragraph 41 about the retraction of that tender.
Yes.
And what
when
I'm
you were
asking...
talking about the first,
On that
thought you were
occasion, I'm talking about the first
second.
one. As I understand Mr. Human's evidence, the first tender was advertised and was retracted in order for an integrated approach to be
Yes,
followed.
yes, okay.
And we're
Then
now moving
we are
on.
done with the first
We're
one.
now done with the first tender.
Okay, all right.
And we are moving on to the second tender,
Yes.
which he's already told us
Yeah.
there was a confinement to one bidder.
Yes.
There was a retraction, and I'm asking whether he...
Oh, I think maybe what we do, because he said that at a wrong time, let's start afresh with the second tender.
Indeed, Chair.
Yeah. Tell us about
the second tender.
It's,
Disregard what you said earlier.
yes, Chairperson, it's not every day that you have opportunity to start afresh, and I would certainly welcome it. Thank you for that, your indulgence. So the second tender was then advertised on the 29th of October 2014. It was evaluated, and then the board asked that this tender be put on hold. And the reason for that was that there was a memorandum of understanding proposed with AAR under a supplier development framework proposal. The board then resolved that this tender be put on hold, the evaluation process. So it was advertised, bids were received, the committee were busy evaluating the results, and midway this evaluation, the board requested the SAAT cross-functional sourcing team to put it on hold for 3 months, while the possibilities of engaging on a memorandum of understanding with AAR are investigated.
Why was the board getting involved in the second tender and in the first tender and the second tender? Was that because the value of the tender required the board to be involved, or what was the reason?
Chairperson, at the time, SAA and SAAT developed a strategic partnership program as a vehicle to advance economic goals, empowerment goals, and it was seen as an opportunity to explore localization. Now, if you allow me to explain a little bit later, the government has a number of instruments that it'd like to use to attract foreign direct investment. The National Industrialization Participation Program is one of those tools. Supplier establishment in South Africa is one of those tools. And it is my understanding that the board were considering using the strategic partnership framework to engage suppliers that would make these kind of investments in South Africa. The involvement was not to approve the tender. Their involvement was to say they consider the framework supplier development framework as a vehicle for empowerment and for investment in South Africa.
Am I right to think that normally a board of an SOE would not be involved in tenders, but that there may be tenders that are above a certain value that have to go to the board? But other than that reason, normally a board would not be involved in tenders. Am I right?
Chairperson, that is correct. The PFMA Act makes specific provision for what is the roles and responsibilities of an accounting authority. In this case, the accounting authority is the board. Their involvement is oversight and governance.
But the reason that you have put forward why they were getting involved, and you have said they were not getting involved to approve or not to approve, as you understand it, that would be in line with PFMA requirements, or is that something you are not sure about?
Chairperson, the involvement of the board would be to approve mechanisms within the legal framework. And the legal framework in this case would be two very specific pieces of legislation. It would be the Black-Based Economic Empowerment Act plus the codes, and secondly the Preferential Procurement Act plus its regulations. Those two would form the legal framework. The partnership agreement, in my understanding, was a specific dispensation for Eskom and Transnet, and it was based on a provision of the Act where those entities had to specifically apply for approval to deviate from the normal instruments. I am not unaware and unsure what motivated the board to use that specific instrument without applying for the approval to deviate from the two main frameworks.
Okay, thank you.
Thank you, Chair. Mr. Human, would it be fair to say that if the tenders had got to that stage, board approval would have been required,
Correct.
but that the board intervened before it got to that stage?
That would be correct, sir.
In respect of what we're calling the second tender, can you just confirm for us when it was issued and what the closing date for the bids was?
Certainly. The tender was published. I'm going to make very sure, Chairperson, that I have number 2 as number 2, if you allow me a minute.
Yes, okay.
The tender was advertised on the 29th of October, and the closing date was the 2nd of December 2014.
And do you know when the suspension decision was made by the board? The decision you referred to where the board suspended the tender?
Yes, Chairperson, the decision to suspend the tender for 3 months was made on the 29th of April 2015.
And the date on which the board finally resolved to retract the tender?
The tender, the board at their meeting of the 18th of June 2015 made the decision to retract the tender.
The reason I ask you those dates is because I'd now like to turn to the portion of your evidence where you deal with the relationship between AAR and SAAT during the period between the issuing of the tender and the decision to retract it.
Yes, sir.
And before you deal with that, these decisions by the board to suspend the tender for whatever period, 3 months, would they normally fall within the function of a board, that kind of decision, or should it be a decision of management, and if the board wants to suggest, they suggest, but the decisions should be taken by management?
Chairperson, it's usually the decision of management, and the regulations, the triple PFA regulations make it clear when you can cancel a tender. It's
Yes.
only when circumstances have changed, or when there's no budget available, or a tender has viewed that there was fraudulent or corrupt activities involved. That would be the three reasons that's currently provided for in the public sector procurement regulatory framework for cancellation of a tender.
Okay,
It is
thank
not
you.
common that a board would take such a decision. It would be taken at management level.
Yes, okay, thank you.
Mr. Human, I'd like to take you to a few aspects of the development of this relationship. If we can pick it up on page 13 of your affidavit, at paragraph 49, you refer to Ms. Jackson, Ms. Cheryl Jackson, approaching Mr. Nico Bezuidenhout. Can you tell us about that approach?
Chair, I have attached the email to my affidavit.
I'm sorry, Mr. Mbikiwa, I may have missed this again. The resolution of the board on 18 June as I look at paragraph 41 of your affidavit, which was done by way of round robin, was to approve the retraction of the tender to allow the finalization of the strategic partnership. That strategic partnership, did you say it was with what organization?
Chairperson, the intent was to enter into a strategic partnership with AAR.
That was the intention.
Correct, sir.
And then it says the board also approved that SAT test the market by requesting quotations from other parties for a 6-month period.
Yes, sir.
Do the two make sense? One, retract the tender to allow for the finalization of the strategic partnership. Two, the SAAT test the market by requesting quotation from other parties for a 6-month. Or maybe it does because maybe the quotations that would be requested would include AAR or not.
The rationale for inviting quotations, Chairperson, is to make sure that the economic value is on par.
Yes.
So inviting a few quotations would get a feel for value for money, usually.
Okay.
And then in item 3, 41.3,
Yeah.
the intent was to deviate from a competitive process and only award it to one bidder through a confinement process, not through a competitive tender.
Yes. Well, Mr. Mbikiwa, when you deal with the relationship, is that when you will deal with some of these aspects? Because
Indeed.
if you will deal with them, it's fine.
We will,
Yeah.
Chair.
Okay.
In a sense, Chair, what we've done chronologically is we've dealt with the beginning of the second tender and its retraction. And the reason for the retraction is the relationship with AAR.
Which you are going to
And we're
deal
now
with
going to move to the chronology of the
Yeah.
development of that relationship up to the retraction.
Okay.
The intervening period.
Okay, thank you.
Mr. Human, I had asked you about the approach that Ms. Jackson made to Mr. Bezuidenhout in February of 2015.
Correct. The email was sent by Mrs. Cheryl Jackson to Mr. Nico Bezuidenhout Mr. Bezuidenhout was the acting CEO of SAA at the time. She thanked him in this email for a meeting that he had with her, and she attached a proposal, a partnership proposal. Chairperson, that would be in line with the strategic partnership proposal that the board intended to put on hold the running tender for 3
Yes.
months to allow for the development of a strategic partnership
Okay.
framework.
Okay.
Except, Mr. Human, in time, the board hadn't yet suspended the tender, had it?
Correct.
So there was an open tender in which bids had been submitted and there was an evaluation ongoing.
That's correct.
In your view, is that common practice to submit a partnership proposal as a tenderer while a tender is open and pending?
And not at all. It is commonly viewed in public sector procurement that when a tender process is running, that interaction with suppliers are prohibited, and it's explicitly stated like that in the supply chain policy of SAA and SAAT.
And then, if we can move to paragraph 51, you speak about a proposed collaboration agreement that emerged thereafter. Can you tell us about that?
Based on the proposal that Ms. Jackson has emailed to Mr. Bezuidenhout, Mr. Bezuidenhout then forwarded this proposal to the SAAT CEO, Mr. Zwane, and this proposal from AAR proposed collaboration between the two organizations in the provisioning of components, the provisioning of components.
Maybe it's necessary, Mr. Mplikiwa, to let Mr. Human just deal with the main features of the proposal so that one can follow the proposal that Ms. Jackson sent to Mr. Bezuidenhout.
Indeed, Chair.
Yeah.
Chair, the proposal is attached as Annexure 9A. If you would allow me 1 sec.
Chair, it's at page 1128.
1128. Thank you. Would that be in another bundle?
Sorry, my apologies, Chair. That's in DD 22C.
DD 22C. Okay. Thank you. 1128.
1128, Chair. That's the email correspondence, and then the collaboration agreement is on the next page as the attachment. It's in draft form.
Yes. Just emphasizing the main features might assist in understanding maybe why later on the board decided to say the tender should be suspended for 3 months pending the finalization of this.
Certainly, Chair. Mr. Human, can I ask you to turn to page 1134, and in particular to clause 5.1, under the heading of collaboration.
Certainly.
Can you read that into the record?
Yes, Chairperson, the agreement states the following. Collaboration. The parties agree to collaborate with each other for the purpose of negotiating this memorandum of understanding in accordance with the terms and conditions of this agreement. For these purposes, the parties record that they intend to execute the MOU by 15 June 2015. The purpose of the MOU is to provide the following. AAR is to be SAAT's major MRO equity partner through a joint venture. AAR is to to be the primary supplier of MRO and supply chain services, including a power-by-the-hour program to SAAT. C, the parties will seek to strengthen the provisioning of SAAT of MRO and aviation services to South African Airways and currently third-party customers. And D, the parties will seek to increase and develop through the JV the business in respect of the provision of MRO services to third-party airlines.
Thank you, Mr. Human. Can you give us a sense of how that collaboration, that proposed collaboration compares to the tender that was at the time underway?
It's virtually the same services, Chairperson. The provisioning of power by the hour was the main component. The provisioning of supply chain and components, repairs, exchanges, modifications, exactly the same. The strengthening of MRO and aviation services in our contract, engineering services, reliability services, modifications on service bulletins and airworthiness directives are included in the current tender.
Thank you. If we return to your affidavit, that's DD 22A, unless, Chair, there's any other aspect of the collaboration agreement you'd like us to go into.
Are you able to say that a reading of that draft does or doesn't give an indication that the later resolution by the board to which you have, about which you have testified, indicate that the board already at this stage of that resolution was looking at AAR being given the job? Is that something that you are able to say based on just reading this and having regard to the resolution, or not really?
Chairperson, it's the absence of any other proposals of equally or better service providers that gives me an indication that it was more or less the only option on the table.
Okay, thank you.
Chair, perhaps we can go to the minutes of the board meeting, which happened the very next day after the collaboration agreement was circulated.
Yes.
That, Chair, you will find also in DD 22C, and that's at page 1055. And if you turn to 105, sorry, Chair.
Is it under any particular?
Yes, sorry,
tab?
it's Annexure 4.
Oh, okay. Yes.
And if you turn to 1056.
Let's just say these are minutes of the board. Is it the SAA board or is it SAAT board?
Chair, it's the SAAT board.
Yes, of a meeting of 29 April 2015 at 9 in the morning. Okay, yes, you may continue.
Thank you, Chair. If we turn to 1056, can you read the first portion of 4.2?
Chair, it is recorded in the minutes. Evaluation of AAR proposal. The board considered the AAR proposal in which AAR sought a partnership, including the option to invest in SAAT, to aggressively expand its regional footprint as well as diversify and increase the revenue. Also, the proposed partnership would help SAAT revitalize its capabilities for jet shop, landing gears, APUs, and component repairs. Continue.
Yeah, please continue.
The board proposed that the following matters be included in the list of SAAT's expectations from the AAR potential partnership. That the efficiency improvement or cost reductions led to lower maintenance costs for SAA Group Airlines. That would be SAA and Mango. That AAR expand into Africa with SAAT as its business partner. That the potential partnership be for a minimum of 5 years and reviewable every year, and thereafter be reviewed by both parties every year, and that AAR would make a cash contribution to the proposed partnership.
And then can you read for us the resolution?
In conclusion, the board resolved that the process followed by SAAT in evaluating AAR as a potential strategic partner in the context of the approved strategic partnership framework be and hereby is noted. 2, the selection of AAR as one of SAAT's strategic partnerships be and is hereby approved and recommended to SAA. 3, the next steps to be taken by SAAT ahead of signing a memorandum of understanding or any other contract with AAR be and are hereby approved. This includes a May visit to AAR led by board chairperson. During this visit, a collaboration agreement, which would be the basis in the memorandum of understanding, would be signed.
Can I pause you for one moment, Mr. Human?
Certainly.
You referred above to AAR, sorry, at the top of the page at D, that AAR would make a cash contribution to the proposed partnership. Is that normal practice?
Not in a procurement process, unless it was specified. No, it's not normal practice. Not in a tender process, sir.
Now, the heading to what you have just read, Mr. Human, is evaluation of AAR proposal.
Yes, sir.
This is being done by the board. Is that also normal, or would the evaluation be normally done by management, who then, if necessary, bring a recommendation to the board, or was this based on a recommendation of the board anyway? It's just that it might not have been put like that.
Yes. Chairperson, evaluation is ordinarily done by management, and if it falls within the delegation of authority, the value of the contract, it will be submitted to a board for evaluation. This strategic partnership process was not put to tender. It was not an open process. This is a proposal that was submitted, evaluated, and adopted. In the procurement speak, one would probably refer to this as an unsolicited bid. There wasn't an RFQ. There was no formal process of inviting bids or testing the market. It is a submission and evaluated and awarded.
The records that you looked at in preparation for your statement, did it reveal whether this unsolicited proposal went, or it didn't go directly to the board, it went to Mr. Bezuidenhout, is that right? Because that we dealt with that earlier.
Correct.
Okay,
It was
and
submitted via email.
He was the CEO at the time of SAAT.
He was the group CEO of SAA. SAA Airlines.
Yes, okay.
And he referred this bid to the SAAT CEO at the time, Mr. Zwane.
Who would then have referred it to the board?
To the SAAT board.
To the SAAT board?
Yes, sir.
Okay, thank you.
Thank you, Chair. I see we are close to the tea adjournment. There's just one further aspect of these minutes I'd like to deal with. The collaboration agreement is dealt with as a separate item in the minutes. If you turn to 1058. Can you just read for us the board resolution into the record at the bottom of the page?
Chair, in paragraph 4.3, in conclusion, the board resolved that Musa Zwane, the CEO of SAAT, be authorized to sign on behalf of SAAT all necessary documentation to effect the collaboration agreement between SAAT and AAR. The SAAT components tender currently underway be placed on hold for 3 months to allow for the finalization of the AAR partnership. And 3, the current components contract with Air France be extended for 3 months from the expiry date to allow for the finalization of the SAAT AAR partnership agreement.
Thank you, Mr. Human. Putting to one side for a moment the relationship with, between SAAT and AAR, the extension of the contract with Air France, what's the lawfulness of that, and does that require a procurement process?
The current public procurement framework allows for the variation or extension of contracts, but to avoid the so-called evergreen extension upon extension of extension, Treasury Instruction 3 has curbed these extensions to a maximum of 15%. And the reason for that decision was to ensure that procurement agencies are allowed to go on an open tender process without disrupting services, but to prohibit extension forever and ever after. So it is allowable, but within that limits specified in Instruction 3 of 2016.
Thank you.
Mr. Mbigio, I was looking for the page which has got that resolution that Mr. Human read earlier on before we came to 1155. I thought it was 1148, but 1148 doesn't seem to be.
Chair, when we were at 1148, we were within, or 1143 rather, we were within the collaboration agreement itself.
I think.
Are you talking about the resolution of, to do with the evaluation of the proposal?
I think so. I'm not sure. No, the evaluation of the proposal is at 1056. The one we dealt with just before we came
just
here.
Just before, is it not 1056?
Okay.
Or just 1057?
Let me just have a look. And no, 1057 is no, it's the one.
Not that one.
Yeah, no, I don't.
Chair, it may have been Mr. Human's reproduction of the resolution in his affidavit.
In his affidavit.
Yes,
okay.
but we can take you to the actual resolution. It's at
yes.
It's at 1079.
1079. Yes, I think I may have been looking at his affidavit reproducing this. The date for that resolution is 12 June 2015. But I see that in terms of the minutes at 10:55, already in April, looks like the board had effectively made similar decisions, or more or less the same decisions. Am I right, Mr. Human?
Chairperson,
I see there's a resolution at 10:57. The process followed by SAAT in evaluating AAR as a potential strategic partner in the context of the approved strategic partnership framework, be and is hereby noted. 2, the selection of AAR as one of SAAT's strategic partners, be and is hereby approved and recommended to SAA. So that's already, that's April.
Indeed, Chair.
And on 12 June 2015, that resolution at 1079 seems to either repeat the same in essence or say something very similar that those resolutions. Am I right? You have had more time
Yes.
to look at these documents than I have
Yes.
had.
Correct, Chairperson. The minutes in 1055, on page 1055, dated 29 April, is the resolution where the board instructed SAAT to put the open tender, that was the second tender we mentioned earlier, on hold for 3 months to allow for the development of the tender. And then on page 1079, the resolution pointed out here is after this framework has been developed and proposing to the board now to enter into the agreement thereof.
Yes. But I guess that already in April,
The
one
intent.
can see the thinking of the board. Is that right?
Correct, sir.
Yes. Okay. Thank you.
Thank you, Chair. That would be a convenient time to break for lunch. For tea, sorry. It's optimistic.
We'll take the tea adjournment. It's 20 past now. We'll resume at 25 to 12. We adjourn. let's continue.
Thank you, Chair. Before the tea adjournment, we had concluded with the board meeting in April, which had resolved to suspend the tender to allow for a partnership with AAR to be explored. You deal at paragraph 55, Mr. Human, with various SAAT personnel visiting the USA. Can you tell us what the documents reveal the purpose of that trip was?
And that's paragraph 55 of his affidavit.
Of his affidavit, sorry, Chair. That's DD 22A on page 14.
Yes.
Yes, sir. The travel records in the possession of SAAT indicates that Dr. Tami, Ms. Quinana, Mr. Zwane, and Advocate Mamela visited the US from the 2nd to the 8th of May. And we have attached as an annex a copy of the allowances for accommodation, transfers, daily allowances, and hotel reservations to substantiate the statement, sir.
Sorry. In your experience, is it consistent with procurement and supply chain requirements to travel to and be hosted by a bidder while a tender is open?
The supply chain policy allows for engagement of suppliers in two manners. One, when samples are required, then there's engagement, and it's well defined in the SCM policy, or as part of the evaluation process. In this case, this process was not at the evaluation stage, and the members that attended this engagement were not part of the evaluation committee. They are of other structure, board members and the head of procurement. So no, it is not practice. There is a provision, but under conditions well defined in the procurement policy to protect both suppliers and the members involved in the evaluation.
And the engagement that supply chain policy contemplates would not include the board, would they? Or members of the board? Or would they include them under certain circumstances? Namely, at, you said the one stage is when they look at samples, and then another one as evaluation stage.
Yes, sir.
Would a member of the board be involved in those stages?
Not at all, sir.
Not at all. Yes, okay.
Mr. Human, this is one aspect that Ms. Quinana has responded to in her statement in response to receipt of a Rule 33 notice. She responds to the implication that it was improper for her to have participated in the trip. It's not necessary to go to the statement. I can give you the nub of what she says. She says that supplier visits are not unusual and that SAAT would not sign an MOU without knowing exactly who they're dealing with. What's your comment in response to that?
If it was an evaluation of a service, the right person to maybe engage in such a visit would be the members of the cross-functional sourcing team. Two, the policy makes it clear that during the evaluation process, contact should be prohibited, except if it was part of the evaluation. And thirdly, Chairperson, the roles and responsibilities of board members or executive authorities are very clearly defined in the PFMA Act under public entities, and that certainly is not one of them.
Just to take you back to the time when Ms. Jackson sent their proposal to Mr. Bezuidenhout. At that stage, had AAR put in their bid already? Because that would have been before the board decided that the tender should be suspended for 3 months to allow the finalization of the MOU. Is that something that you are able to clarify? Namely, whether when Ms. Jackson sent the proposal for this partnership, she was, or AAR was one of the bidders who were expecting their bids to be considered.
Correct, sir.
Okay.
Indeed, Chair.
Yes.
Mr. Human's earlier evidence was that the closing date of the bid was the 2nd of December
Yes.
2014.
Yes.
And Ms. Jackson sent the proposal on the 26th of February 2015.
Yes.
So it was after the closure and during what would have
Yes.
been the evaluation stage.
Yes. Okay.
Mr. Human, there's then some correspondence that's attached to your affidavit that I'd like to take you to. If you can turn to 1266 in Annexure DD 22C. 1266. Are you there?
Yes, sir.
This is an email from Ken Hein to, that's H-E-I-N, to Ms. Nonsasa Mamela. Do you know who Mr. Hein is?
Mr. Hein is a senior manager or senior executive at AAR at the time.
And in this email, Mr. Hein indicates that he and Mr. Fiddis will be arriving on Wednesday morning and staying at the Intercontinental Hotel, and he asks if Ms. Mamela can fetch him. He then attaches some topics for discussion. If you go over to 1267, if you look under discussion topics,
Yes, sir.
at the first bullet point, can you read that one?
A full understanding of SAAT support requirements and needs versus the RFP.
Now, this is at a stage when the tender has not yet been retracted. Would that be an appropriate discussion for a bidder to be having with SAAT?
Totally inappropriate.
Can I ask you then to turn to 1263? It's just a few
Well, I'm sorry, Mr. Mplikiwa. The second bullet point seems quite interesting. Current SAAT support,
Indeed, Chair.
likes and dislikes of current support provided. Do you know what that's about? The likes and dislikes.
Sir, I have no written evidence of what that
Of
might
what-
mean.
yes.
I'll have to interpret, but
Yes.
no.
Okay, all right. Well, you have dealt with a lot of correspondence and minutes of meetings. Are you able, based on your understanding of various minutes and correspondence that relate to this, are you able to say what you think that meant?
Yes.
What do you think it meant?
Chairperson, I am of the opinion that there is also evidence in the other documentation that the case was built that the service of Air France are unacceptable, and it's used as a motivation why this agreement should be further pursued. It is my notion that this formulation probably points to performance services and operating models that will be better suited to SAAT than what the then provider Air France were able to do.
So the current supplier at the time was Air France.
That's correct.
And the reference in that second bullet point to current SAAT support would be, on your thinking, would be a reference to Air France.
Correct, Chairperson.
And therefore, when it says likes and dislikes of current support provided, it effectively, you say, refers to what it is that SAAT didn't like about the current support and what it is that they liked,
Yes, Chairperson.
which I think only logic says it would mean they want to emphasize on the likes for their purposes and magnify the likes if you criticize maybe the current support.
Absolutely, Chairperson. It is probably a method to solicit information
Yes.
that would strengthen the proposal that the supplier then would have put forward.
Yes. It is the kind of information that they would have wanted to use to strengthen their own either bid or, if not bid, the drive for this collaboration.
Correct, sir. A common practice that's provided in the procurement legislation is so-called briefing sessions. And then in an unbiased and a manner that doesn't favor only a specific supplier, this kind of information will be presented to all potential suppliers. Government entities are given the opportunity to make it a compulsory briefing session, and that would have been probably the correct vehicle to use to share information that bidders could use to strengthen the bid and prepare a quality proposal during the evaluation phase. But it's certainly not practice and acceptable to share information with only one supplier and would constitute an unfair advantage.
Yes, thank you.
Thank you. Can I ask you then to turn to page 1263?
I'm on 163,
1263.
correct.
You'll see at the bottom there's an email from Ms. Sonia Lopez to Ms. Mamela asking for transportation for various people from the Intercontinental Hotel. Above that, Ms. Mamela forwards that to Mr. Mike Kenny. If I can ask you to then turn back to 1262. Ms. Mamela then says, "Thanks, Mr. Kenny. Could you please let me know when your guy goes to fetch them so I can leave Premier Hotel to there? Further take note that we will be using operational purchasing boardroom." And if I can ask you to turn one page back, 1261, Mr. Kenny informs Ms. Mamela that he will not make the meeting. Ms. Mamela above that asks him why. If I can go one page back. Can I ask you to read Mr. Kenny's email at the bottom of 1260?
Certainly. Mr. Kenny responds to Advocate Mamela. "I have a meeting with a customer regarding work in Uganda taking place in Kilnary, and I'm concerned about discussing component support issues with somebody who is a bidder in a process, and the process is still ongoing corporate governance issues. However, I would not be available for this meeting anyway due to prior arrangements which have been confirmed."
Thank you. And do you know who Mr. Kenny is?
Mr. Kenny was the General Manager Marketing, or Acting General Manager Marketing, is a senior executive on the SAAT Exco.
And the concern that Mr. Kenny is expressing there, is that one that you would share?
Absolutely.
And the email is addressed to Ms. Mamela.
Yes, Chairperson.
Yes.
You'll see Ms. Mamela's email above that says the process has been put on hold, to which Mr. Kenny then replies and says, "I understand that it is on hold, but that means it is still open and ongoing." Is that also a view you would share?
I would subscribe to that, yes, sir.
So in other words, that it's on hold is no valid reason to have these kind of interactions with one of the bidders.
Correct, sir.
Yeah.
It was a postponement or a hold for 3 months but the bid was active.
It had not been cancelled or
Correct.
anything like that.
It means that it could be continued and finalized. So it would be inappropriate to engage with suppliers while there was an open bid under review.
Would it be an answer to say, for what it's worth, would it be an answer to say the bids would be, the closing date had come and gone. The bids were in, and whoever needs to evaluate them and consider them is bound to consider them on the basis of the information already put in, and not on the basis of any information that they might get from other meetings. Would that be an answer at all?
That would be correct, Chairperson. The information to be evaluated during the bid process would be what is submitted on the official closing date.
So, to the concern that Mr. Kenny raises, could Ms. Memela say, there's nothing that we are going to discuss that's going to find its way back into the bid or find its way into the bid documents. So therefore, there's no problem with me meeting with them.
The argument that Mr. Kenny tries to convey that it is contrary to the provisions of the supply chain policy to engage suppliers while there's an open bid at hand. Even if Advocate Mamela would argue that any additional information would not be considered during the bid, it's still a very exposed process for undue influence.
If she was not going to be involved in any adjudication of the bid, would that make a difference? In other words, her meeting with a bidder in circumstances where the closing date had come and gone, and she was not in any way going to be part of the people who would adjudicate the bids, would that be an answer to say, well, it can't possibly affect the bids because I don't sit in the committees that decide, and whatever we might discuss, they can't supplement their bid. Whatever they have put in, that's how their bid will be judged.
That would be a correct interpretation, Chairperson, but Advocate Mamela was the Chairperson of the group BAC, and can I just confirm the date?
Yeah, no, it's enough if you say she was Chairperson of the BAC, so on your understanding, she would be involved in the adjudication of the bids?
As Chairperson.
So that argument would not be available to her?
Correct, sir.
Okay, thank you.
Thank you, Chair. The last piece of correspondence, Mr. Human, I'd like you to turn to is in the same file at page 1278.
So maybe just to complete what we were talking about a minute ago, Mr. Human, then the prohibition of any interaction with a bidder while a bid is, a tender is pending and has not been decided, the rationale for prohibiting that kind of interaction would apply to her fully, because although this particular bidder could not add any document to its bid, whatever was discussed here could well influence her thinking in making the decision, even though it might be something that is not on the papers, on the bid.
That would be correct, sir.
Yes, okay.
Thank you, Chair. Mr. Human, at the bottom of 1278 is an email from Ms. Jackson, where she says, "Hi all, last week Chris Fiddis, Ken Hine and I met with the SAA team and leadership. Below is a scope of work and list of initiatives that SAAT would like to work with AAR on or explore further as part of our partnership." If I can ask you in that scope of work just to turn to 1280 and under timeline.
That 1280.
Yes.
Okay.
Under timeline, can you tell me what it says next to June 5?
It reads, SAAT power by the hour RFP, request for proposal, cancellation becomes official.
Does it strike you as odd that AAR would be aware, Ms. Jackson's email is dated the 4th of June, would be aware that a cancellation of a tender in which it was a bidder was becoming official?
That strikes me as odd, yes, Chairperson.
Do you read that item to mean that SAAR had been given information that on that date, namely 5 June, the request for proposals would be cancelled officially?
Yes.
That's how you read it.
Yes, Chairperson. It appears irregular that a bidder is aware that there will be a cancellation prior to the date of that cancellation. It would suggest to me that information were made available to the supplier outside of the normal procurement process.
If you stay in the timeline and you go to June 15 to 17, it says PBH contract meetings during Paris Air Show, sign MOU, BEE structure discussions June 22 to 26, SAAT MRO. Then at June 30, what does it say there?
Sign power by the hour contract with SAAT.
Does that strike you as unusual at all?
Yes, because this would be a contract out of a normal procurement process, and it would be quite strange to cancel a tender but then to sign a contract.
For what looks like the same services that were the subject of the tender?
Yes, Chairperson.
If we can then return to your affidavit, Mr. Human, that's DD 22A. And we pick it up from paragraph 68. Can you tell us whether an MOU was ultimately concluded?
Chairperson, a MOU was concluded and submitted for signature during the Paris Air Show.
And are you able to say what, in broad terms, it provided for?
I'm sorry, did you say paragraph 68?
68, Chair.
Okay. Yes.
It's from 68 onwards, Mr. Human deals with the MOU.
Yes.
Mr. Human, are you able to say in broad terms what the MOU provided for?
The MOU provided for the collaboration between AAR and SAAT concerning the provision of components the so-called joint venture that was contemplated, and I have annexed it to my affidavit, Chairperson, as SH27.
Thank you. Chair, I don't think it's necessary to go there.
Yes. Let me ask this question. They call this a collaboration agreement. Is that right?
Yes, sir.
At that stage, did the collaboration agreement not already give AAR the right to provide the services or components that were the subject of the tender, or it was just a precursor to that kind of agreement?
Chairperson, on this date, the collaboration agreement was not yet formally signed. It was only the MOU indicating the intent to end up in a formal signed contract. Later on in this affidavit, we do elaborate a little bit more on how that process unfolded.
Okay.
On the further negotiations for a more definitive contract, well, I think let's go there,
Sure,
Mr.
sure.
Human. You deal with that at paragraph 82.
That's correct.
Tell us what the agreements referred to there are.
Chair, the intent was the process of confirming the collaboration agreement was initiated by Mr. Fides by email, where he submits a draft letter of agreement and where he requests clarifications. Now, the main intent was to enter into negotiations for the acceptable definite written agreement in the provisions. That's the standard terms and conditions. The services, the scope thereof, and obviously I anticipate pricing would be part of that. It specifically pertains to rotable component services, which was the intent of the original RFP in the first instance. The letter contains a reference to exclusivity that makes it incumbent on SAAT not to engage with any other potential service providers. So this agreement, the collaboration agreement, is nothing else than the request for proposal in a different format called a collaboration agreement. In its intent and spirit, it's exactly the services that was required from the through the RFP process.
And Mr. Human, this is on the 3rd of July, so it's after the board has resolved to retract. Would it be fair to say then that SAAT and AAR are in negotiations to conclude a contract for the very services that had been the subject matter of the tender that was retracted?
Chairperson, that would be an accurate articulation.
I'd like to jump ahead in the chronology a bit to concerns that were raised about what we've been speaking about by one of the board members, Mr. Parsons. Are you able to articulate for us what concerns he raised?
Chair, Mr. Parsons was a non-executive director serving on the board, and he had certain concerns. They relate to governance They relate to the fact that the MOU were not made available to the board in time, and that his comments on what he saw as fault lines or weaknesses in the MOU were not adequately addressed. He was also concerned that in terms of Section 54 of the PFMA, executive authority like SAAT needs to engage the National Treasury when it intends to enter into unincorporated joint ventures, amongst others. He addressed his concern in writing to the company secretary at the time.
And what was done in response to his concerns?
Legal opinion was invited through the group legal services, which solicited an opinion from a private firm called Cliff Decker Hofmeyer, and the expert that was assigned was Mr. Ori.
And what further steps did Mr. Parsons take?
Mr. Parsons thereafter raised his concerns to the chair of the board, Ms. Quinana, where he expressed his concern that the MOU with the points that he indicated as served before the SAA board with any improvements or alterations that would address his concerns and mitigate what he has pointed out as governance, breaking governance.
And what was Mr. Parsons' final step?
Mr. Parsons then submitted his resignation with immediate effect, and that chairperson happened on, sorry, if you can just help me to get the exact date.
I am going to ask you to go to Mr. Parsons' resignation letter.
Sure.
If we can go to DD 22D.
And what's the page number?
1676.
One
1676. Can I ask you to read the first two paragraphs of that?
Certainly. Chairperson, the heading is Resignation from SAA Technical Board. Please accept my resignation with immediate effect from the Board of Directors of SAA Technical SOC Limited. I feel I have made a strong contribution to the board, finding governance in the business weak after what appeared years of neglect. Unfortunately, the value I can add seems no longer wanted, and it's quite clearly due to the AAR Corporation's strategic partnership. There is clearly a hidden agenda somewhere in this relationship, and it requires urgent independent investigation. Independent is underlined in this paragraph.
Thank you. So would it be fair to say that Mr. Parsons' sole reason for resigning is the proposed partnership with AAR?
That is correct, sir.
It might be necessary to highlight some of the features of other features of the letter. I'm not sure.
Indeed, Chair.
Yeah,
Chair, the
maybe,
thrust of the letter is Mr. Parsons raising issues,
yes.
the fact that the issues he's raised in the past have not been adequately addressed.
Yeah, I think let Mr. Human just read the whole of that letter.
Okay. Please go ahead.
It seems to be an important letter.
Certainly, Chair.
Chairperson, the third paragraph reads as follows. A memorandum of understanding was signed by SAA Technical Management with AAR on 16 June 2015, which, based on the version finally distributed at both my insistence and persistence to the SAA Technical and SAA boards on the 1st of July, is fundamentally flawed. I sought guidance on this matter from the SAA Technical Board Chairperson on the 2nd of July. However, I have received only a poor and evasive explanation from management, and I was shocked to see the same version of the MOU submitted to the SAA Board, the shareholder, for the board meeting on the 10th of July, over 3 weeks after the execution. On 13 July, the SAA Technical Board Chairperson offered to meet to understand my concerns, and this was scheduled for 17 July and then postponed to the 24th of July. My concerns are quite concise and summarized in the attached email thread Annexure A. However, there appears to be no hurry to ensure either SAA Technical or the SAA boards are either briefed or receive the correct version of this MOU and are able to understand the full implications of the strategic partnership or any implementation steps already completed 5 weeks after the execution. Apart from the lack of visibility of the precise nature of this relationship and the overall governance, I have specific concerns whether the requirement I raised at the last SAA Technical Board meeting in May for the partnership to deliver lower maintenance cost to SAA and Mango is fully considered. Having cancelled the components tender to accommodate the exclusivity in the AAR relationship, we are already adversely impacting both SAA and Mango's maintenance cost for the financial year 2016 from a position where the cost base of SAA Technical is already uncompetitive. This consequently impacts the cost compression targets committed to National Treasury in the 2015 SAA Corporate Plan. My other specific concern is the identification and selection of BE partners for the purpose of a joint venture, a process that needs to be highly transparent in a business that already has an uncompetitive cost base. The copy of the MOU received includes an implementation timetable that suggests the process may already be significantly advanced, and there is no visibility of this to either the SAA Technical Board or to National Treasury. I hope the company shares my concerns and appreciate I can have no confidence in the integrity of the SAA Technical Board, and my membership of that board has become a reputational matter, and it is a simple decision to submit my resignation. Yours sincerely, Barry Parsons.
Well, I didn't ask you a certain question that I thought I would ask you much earlier. When we were looking at one of the resolutions of the SAAT board that we looked at earlier, there was a resolution that was approving the conclusion of, I think, memorandum of understanding with AAR, and then towards the end the sentence said, and recommended to SAA. Do you remember seeing something like that?
Yes, Chairperson.
Was that in regard to the MOU, or was it in regard to something else?
It was specifically to the MOU.
MOU. I wanted to find out what your understanding is of that last portion, that the SAAT board was recommending something to the SAA board, and if it was the MOU, what's your understanding of how that came about? How does the board of one entity recommend something for the board of another entity, even if they are in the same group?
Yes. Chairperson, SAAT is 100% owned by the SAA SAA main group, and therefore the main shareholder. So in the framework, there is a requirement to report on material transactions. This would constitute a material transaction. My understanding is that the board's rationale to submit it to SAA was first for noting purposes, but also because it represented a huge financial aspect of its annual turnover.
I may have misunderstood that portion of that resolution. I thought it meant something along the lines that the SAAT board was recommending that SAA should have a similar MOU with AAR, but probably that's not what it meant. It meant they were recommending that SAA should approve that they have this MOU with AAR. Is that right?
That's correct. The intention was not for SAA to have a similar MOU.
Yes.
It was a submission for the noting and endorsement by the SAA board.
Thank you. Mr. Human, if we can return to your affidavit, I'd like to now move on to tender SP 45115 and 45315. That's in DD 22A, the file with your affidavit, on page 28 from paragraph 98.
And before you do, you move on, Mr. Parsons' letter of resignation says at the end of paragraph 2 that there should be an urgent independent investigation. Do you know whether the company secretary or the board, either of SAA or SAT, took that suggestion and followed it up?
Chairperson, yes. A legal opinion was requested from Cliff Decker Hofmeyer, and I think we are going to deal with that shortly.
Did you say Advocate Hofmeyer?
Yes.
Not this one. Okay.
There was a slip of the tongue, Chairperson.
Okay.
No pun intended.
Chair, it's not clear to me that that was in response to Mr. Parsons' resignation letter, because the opinion that we have from CDH is a draft preliminary one which predates Mr. Parsons' resignation. I'm not sure that we're aware of any other independent investigation that was undertaken post Mr. Parsons' resignation.
Mr. Human, do you go along with that, or do you know that there was some independent investigation that followed his resignation based
Chair,
on the correspondence and minutes that you have seen?
Chair, I was of the opinion that the email dated 27 July on 97, paragraph 97 of my affidavit is a response to Mr. Parsons' concerns, and that Mr. Ori, in his response to the legal department and Advocate Mamela, says that Mr. Parsons has mostly raised non-legal issues. But the only thing that that needs to be corrected is the signing of the MOU and then to submit it to the board. I'm referring to paragraph 97 of the affidavit and Annex 54A as a supporting document.
Yes.
Is that correct? I think, can we clarify just the timing? Mr. Parsons resigned on 24 July.
Indeed.
And then this email that was provided to me and that I have access to confirms that on the 27th July this response has been forthcoming.
Chair, we can go to the response from Cliff Decker Hofmeyer. I don't think it's an independent investigation it's a response from
Issues.
Mr. Ori to the internal legal person at SAAT,
Yes.
simply saying that he can't really deal with it because it raises some non-legal issues.
Okay.
I agree with that.
Okay, you agree with
Yeah.
that, okay.
Chair, of course, the independent investigations that we do have in the record are those conducted by Open Water, but
Yes.
that of course occurs much later in
Yes,
2017. Mr. Human, can we then deal with tender SP 45115 and 45315? What were these tenders and how did they differ from the previous ones?
We're going back to his affidavit
We're at his
now.
affidavit, Chair, at page 28
Yes, okay.
on paragraph 98.
Chairperson, these two tenders are now number 3 and 4 of the 5 tenders that were published to solicit the component services. It was agreed that this should be a closed bid and that SAAT would only invite a number of suppliers. So in tender number 3, 45115, was a short-term tender to obtain services for 5 months. And it was issued to only 5 suppliers: Air France, Israel Aerospace, Pegasus, and Lufthansa. Later, I
Continue.
apologize.
Please continue.
It later appeared from the advice also from CDH that SAAT would be at risk not to invite a bid from AAR. The reason why AAR was excluded from the closed bid is unbeknown to me, but it was remedied when this very same tender, the very same request for proposal, was then issued under SP 453/15 to AAR to make this process complete. So 453 is really just a reissuing of the same tender also to AAR.
And what's your understanding of why they were only for a 5-month contract?
The reason why it was only a 4 or 5 month contract is to allow enough time to finalize the agreement with AAR, with a collaboration partnership.
So in other words, it's in pursuance of the board resolution retracting the previous tender.
Correct.
Can you recall whether AAR did submit a bid?
Yes, AAR did submit a bid after asking for extension in the response time.
And do you remember who its BEE partner was?
The bid submission that was submitted indicates that AAR identified Nziza Aviation as its strategic partner.
And who was this tender ultimately awarded to?
This tender was also not awarded. A decision was taken to extend it to Air France for continuity of service, the rationale being to conclude the agreement with AAR in the meantime.
Your evidence at paragraph 114 is that the board in fact, resolved to award it to Air France,
Correct.
but that was an award of the tender.
It was award of the 5-month tender.
So just to clarify from your previous evidence, was it simply an extension of Air France as the incumbent, or was it an award of a new tender to Air France?
It was an award to Air France, not an extension.
All right. Much of what you have dealt with in respect of these two tenders, we heard from Ms. Sambo yesterday. So I intend to proceed to what you've described as the 5th tender and to deal with some of the process issues in respect of that in some detail. So if we can turn to page 37 of your affidavit, can you tell us what this tender was and how it differed from previously?
This tender is a request for services for 5 years for a component tender, and is in essence the very same as the previous tenders.
I'd like to take you to the bid invitation document just to focus on a few clauses in it. If I can ask you to go to Exhibit DD 22E and page 2043. It's DD 22E 2043. Can you read for us what the date issued is?
This tender was
Sorry. Let me pause. Chair, I see you haven't yet got your file. It's 2043, Chair.
2043.
Exhibit 84.
What is this? Is this an RFB?
This is the RFB for what we're describing as the 5th tender.
Yes, okay. On the affidavit, where does the 5th tender start?
The 5th tender starts on page 37.
Oh, well, the heading is on 36.
Yes, the heading is at the bottom of the page, but
Yeah.
there's no paragraph below it.
Okay.
So we start at paragraph 133. Mr. Human, can you tell us what the issue date and the closing date was of this tender?
yes, so the issue date was 8 December 2015 and the closing date 19 January 2016.
Thank you. And if I can take you just to a few clauses in this document, can you turn first to 2062?
Well, maybe let's first get the witness to confirm where the document ends. It starts at 2043 and ends at what page? Is it 2086?
That's correct, Chairperson.
Okay, all right.
Thank you, Chair. Are you at 2062?
Yes.
And what is that table?
The table found on page 2062 is the critical criteria that suppliers are required to comply to qualify for this bid.
What's the consequence of not complying?
If the critical criteria is not met, the bid will not proceed to the next phase of evaluation.
In the table, if you go,
Well, let him read all of them.
okay, if you would read each of those critical criteria, Mr. Human.
First one is sufficient experienced and equipment.
Sufficiently experienced and equipped.
Equipped.
Yeah.
Thanks, Chair. Is of sufficient sound financial standing to carry out satisfactory any contract that may be awarded pursuant to the tender. Must be certified for FAA and EASA as a repair station. FAA is the Federal Aviation Authority, the American equivalent of our Civil Aviation Authority, and EASA is the European Aviation Authority. Must offer an access pool or exchange basis, no fault found rate 20%, BER rate.
Do you know what that requirement relates to? No fault found rate? Is that a rate for what?
Chairperson, sometimes
If you know.
I know. A component might be removed, sent to a repair facility, and when they test it, it's working perfectly. And to encourage MROs to do decent fault finding before spending excessive money, they charge a rate of 20% to deter this practice of just willy-nilly sending a component for testing.
Okay, all right.
BER rate is beyond economic repair rate of 70%.
Can I just pause you there? What does it mean for the BER rate to be 70%?
And just remind me also what BER stands for.
Chairperson, when a component is faulty and sent to a repair facility, and the repair cost would eventually be more than the cost of a new one, then it's not really worthwhile to...
it's like a write-off if it was a car.
Yes, sir.
Okay, all right.
It's not worthwhile
to repair it.
Yeah, and instead of then paying the full value of the repair, this tender asks for that 70% will be covered, and that the SAAT would only pay 30% of the value. So this.
So yes, at a practical level, let's say a component was found to be a write-off, as it were. What would that mean for SAAT in the or for any service provider or any entity in its position? What did this mean? Did it mean that they would be charged 70% of what otherwise it would have cost them to have the component repaired? In other words, there is a special dispensation that although normally you would not repair such a component because it's a write-off, you will repair it, but you will charge us only 70%. Is that what it means?
Chairperson, more or less, it means that if a component is found that the cost of repairing it would not really be worthwhile, it should be written off, that the supplier needs to carry 70% of the cost. So if the value was 100 Rand, 70 Rand would be for the account of the supplier, and SAAT would need to pay 30 Rand towards this component. It's almost like an insurance policy. Every month you pay insurance for your car, and if it's written off, there's an excess amount that you need to pay to repair it. It's the same principle.
But why would SAAT, for example, want want a part that's supposed to be written off back and pay for it? Is it because a new one might be more expensive?
It would be actually cheaper to have a new one than to repair it.
So why would they want one that is old and has been used when they can get a new one cheaper?
Yes,
Or am I missing something?
No, it's very pertinent and relevant questions. If I could like to clarify. When a component becomes beyond economic repair, it needs to be scrapped. It would be defaced, cut up into pieces and discarded. But to replace the unit in the inventory of the pool, you need to contribute to buying a new one, and we share the cost. So SAAT would pay 30% towards the purchase of a new one, and the supplier 70%. It's a mechanism. These components are quite expensive. It's not uncommon to pay 3 or 4 or 5 million rand for a component, and then the cost is just not possible to bear for the airline. So this mechanism is possible to share the cost. The equivalent of insurance premium would be the flight hour rate. So if I may give a practical example, at the moment, SAAT pays more or less $100,000 every month towards possible BR occurrences. That's like the insurance policy. If a component fails, say it was a Adiru is a component that's used to measure airspeed, temperatures, and the instruments it's linked to the instrumentation in the cockpit, but it's quite expensive. It costs about 5-6 million rand. Then SAAT would only pay 30%, and the supplier must pay the remaining.
Okay. Thank you. Yes, you were still going to finish just reading into the record all those requirements.
The next one is AD. AD is mandatory. AD is an airworthiness directive.
Mm-hmm.
Many times manufacturers would issue improvements. It's like maybe you get a new version of Microsoft on your computer. In this case, it is a directive. It's compulsory to replace. AD is non-mandatory. Warranties, the sessions of warranties to reduce rates. Chairperson, if you buy a new aircraft, it comes under warranty, and any components that would be faulty will then fall under a warranty claim. This criteria is for the supplier to deal with those warranties that can be sometimes quite complicated. Supplier development must equal to 10% of the contract value, and a proposal needs to be included. Reciprocal work must equal to 10% of the contract value and must include a proposal. It must be willing to enter into a partnership joint venture with SAAT, which is equal to 10% of the contract value, and must be a 24-hour, 360 days per year service.
Thank you.
Thank you. If you can then turn to page 2064, and you'll see the table at the bottom of that page. You referred to one of the requirements being supplier development. Just describe, it's not necessary to read the block, but just describe for us what supplier development is.
Supplier development would be initiatives that will empower local suppliers to become competitive in this industry. It also deals with a localization, SMME development, job creations, and is aligned to the government's developmental objectives of empowerment described in the BEE Act and the PPPFA Act.
Can I ask you to just read the last sentence of that block? into the record.
A bidder to indicate what value they would place on each area of development based on the above and which they would be imparting to the local vendor.
Thank you. And then lastly, if we can go to 2085. This refers to something you spoke about earlier, the NIP obligation. Just tell us what a NIP obligation is.
A NIP obligation will be applicable to any contract that's worth more than 10 million US dollars over its term. It requires agreement with the DTI on the scope thereof, and that at least 30% of that contract value be applied to obligations back into the country.
Please remind me about what NIP stands for, okay?
Chairperson is the National Industrialization Participation Program.
Okay, thank you.
Thank you. We'll return to those aspects when we discuss the contract and its implementation. Before we get to the evaluation and adjudication of the bid, you've dealt in your affidavit, and we return.
We're going back to
we're
the
going back to the
affidavit.
affidavit. Sorry, Chair.
Yes, just remember to announce.
I will, Chair. Sorry about that. We are back in DD 22A.
Okay, and what page must I go to?
To page 37, please, Chair, of the
Okay.
affidavit.
Okay.
Sorry, that's a mistake. It's 38.
Okay.
And you deal from paragraph 137 onwards, Mr. Human, with documents that reveal a property purchase and salary increases granted to Ms. Mamela. Can you tell us about that?
Chairperson, I've been provided with documentation that demonstrates that Advocate Mamela purchased property in Bedford View to the value of 3.8 million rand, and that it was registered on the 11th of July.
I'm sorry, which paragraph at 38?
From paragraph 137, Chairperson.
Okay, all right.
In addition, we have documentation confirming a salary increase for Advocate Mamela approved by the SAAT acting CEO and chair. SAAT chairperson. We are not sure whether this was a performance-related increase or what would have triggered the increase at this stage.
Does the increase in her salary coincide with the customary time when increases are effected on staff remuneration at SAAT? Or is that something you would not know?
Chairperson, it is out-of-cycle salary adjustment, which I gathered from the documentation submitted, referred to in paragraph 140.
Okay.
So it's not the normal
Annual.
annual
Yes.
increments or increase percentages.
Okay, all right. You might wish to raise your voice a bit. I think it might be going down so that everybody can hear you.
Certainly, Chairperson.
Mr. Human, those facts were included in the open water investigation. Are you aware if the open water investigation discovered that JM Aviation paid 2.5 million rand towards a house that Ms. Mamela bought in 2016?
Based on the report, yes.
But can we then turn to the evaluation and adjudication process in the tender? And that you,
That last bit, is that in a page somewhere else, in another document, not in Mr. Human's affidavit?
no, Chair, it is not. In fact, that was not in the open water investigation.
Yes, okay. But Ms. Memela has been notified about it.
The fact that she bought the house
Yeah.
is in the open water investigation. That's subject of the investigation.
Yes.
What I'm asking Mr. Human is whether he's aware,
Yes.
whether open water discovered that JM Aviation paid 2.5 million rand.
Yes,
towards
no,
the
what I'm
deposit.
asking is whether that report, she is aware that that report will be part of what we'll discuss here.
Oh, indeed, Chair. We've
okay.
engaged with Ms. Mamela about that.
Okay, all
Yes.
right. Yes,
Can we then turn to the evaluation and adjudication process, Mr. Human? We pick that up at paragraph 141 on page 39. Can you talk us through what happened in the evaluation process of the fifth tender?
Yes, we've already, Chairperson, indicated that this tender was published in December 2015 and closed in early 2016. After it was received, a cross-functional sourcing team convened, and they embarked on the evaluation of the tender. They used the criteria that we have referred to earlier as the basis for evaluating compliant bidders, and then they processed to consider the financial offers. During this process, Chair, I'd just like to clarify, the question is specifically about evaluation, also including the adjudication.
If we can just deal with the evaluation in the
Okay.
first instance.
Okay, the chairperson of this committee was a Mr. Roberts. At the time, he was responsible for chairing this committee and part of the procurement department. The evaluations took place and bidders were asked for best and final offers. Reduced bids were then returned during April, where the bidders indicated reduced prices. Final submissions were then considered, and the cross-functional team signed off. Unfortunately, it's an undated document, which I refer to in paragraph 146 of the affidavit.
And what was the recommendation of the CFST? You deal with that at paragraph 147.
So, Chairperson, after this process, the recommendation was that Lufthansa be that Lufthansa is appointed for both the Boeing and the Airbus fleets. The CFST recommended the winning bidder or the recommended bidder to be Lufthansa.
And tell us what happened next in the process.
And Lufthansa had offered the lowest price, is that right? I'm
That's
looking at
correct.
145.
Yes, Chairperson.
And then the next lowest was JM/AAR Corporation, and then Air France, is that right?
Chairperson, no, the next step was that after this recommendation, the cross-functional team was requested that they should ask the bidders to confirm whether they actually understood the scope well. And they have to provide written confirmation to this effect and supply a list of their current customers before submitting yet another best and final offer. I'm in 41.8.1 chairperson.
Where are you?
148.1 chairperson at the top of page 0041.
Yes, I was asking you something that is at 145.
I apologize, Chair.
Yes. Mr. Mbikiwa, was
Yes.
this covered and I just missed it? Or,
No, Chair, it wasn't.
were you planning to
I'm
come
grateful
to
for
it
you for going there.
Yes, okay.
Mr. Human, the question is, after the final submission, you've spoken about the best and final offer process.
Correct.
After those best and final offers, my understanding of the Chair's question is, what was the ranking of the prices of the bidders?
Lufthansa offered the lowest price, chairperson.
Yes. And then,
That was followed by JM Aviation, or JM/AAR Aviation, and then Air France.
yes, okay. Okay, you can
I see
continue.
that in response to the last of the best and final offer requests, AAR reduced its price by 49 million. Is it common practice to have best and final offers in a tender process like this?
It is a common practice to negotiate on price. Yeah, it's practice to ask for better price quotations.
Thank you.
So when that is asked, it's basically to get the bidders to give their final position on prices.
Yes, chairperson.
But it need not be prices only, it could be other aspects of the bid that they put up, which might enhance their prospects.
Chairperson, usually evaluation committees finish their evaluations in totality and then would enter into negotiations with the winning bidder. And in that process, price, beneficial terms, quality standards, and training or other benefits would be negotiated. In big tenders, that's usually how the process is run, if it's following this in this pattern. But to negotiate with all bidders is possible when there's a so-called two-envelope system, when bidders go through a functionality, everybody that passes functionality, the critical criteria, then goes to the second phase.
But my question was, is it correct that when a request is made for a bidder's best offer, that's not necessarily limited or confined to price?
Yes,
It
sir.
could include other terms and conditions or other aspects that the bidder thinks if they made some amendments on, that could enhance the conclusion of an agreement.
Yes, chairperson, that does happen.
But mostly it's the price.
It's mostly price, and then after an award, all the other conditions are negotiated.
Yes, okay. Okay.
Mr. Human, you were then, after telling us the different prices after the final submission and the recommendation of the CFST for Lufthansa, you were busy telling us about the meeting, the CFST meeting of 25 April, which you deal with at 148. Do you want to finish telling us about that
Yes.
meeting?
So, chairperson, after the evaluation and the submission of the cross-functional team recommending Lufthansa, on the 25th of April, the cross-functional sourcing team once again met, and based on the minutes of this meeting, it is disclosed that that all suppliers were requested to confirm that they understood the scope correctly and provide a list of the current customers with a second best and final offer. The rationale for this decision, Chairperson, was that the prices were regarded as
Too low?
quite low, yes. In the industry, it's called lowballing,
Yes.
where a bidder may be under quotes, but then later the service is compromised due to financial constraints
Yes.
or possibly a compromise in quality.
Yes.
Chair, this might be an appropriate time at which to take the lunch break.
I wonder whether it might be convenient to finish what he has to say about that meeting, unless you think it's going to take quite some time.
No, I think I think
Let's
that makes
finish that
sense.
meeting,
Let's finish the meeting. What else happened at that meeting?
At the meeting, Advocate Mamela also joined, and she emphasized the urgency to finalize this project. The meeting took note, the cross-functional sourcing team meeting took note of the feedback on pricing of the three bidders, that being Lufthansa, Air France and AAR, and the risks that was identified were considered at this meeting. The meeting also noted that although Lufthansa is the lowest bidder, there was still outstanding NIP obligations, and that should be a concern to the team.
And what was the conclusion of the meeting?
The cross-functional team then changed its recommendation to award the contract to Air France.
And just one last question. Is it normal practice? You said earlier that Advocate Mamela was the chair of the bid adjudication committee. Is it standard practice for the chair of the bid adjudication committee to attend a meeting of the CFST?
No, it's not normal practice, Chairperson.
I'm sorry. It's what is not normal practice?
The principle of adjudication committee and of evaluation committee is segregation of duties. So it's not common that the chairperson of a BAC would attend the proceedings of a cross-functional team.
Because the one is higher than the other,
Yes.
and they have different functions.
They have different functions, and the intent is that there should be checks and balances. It's a way to keep each other accountable.
Yes. Well, you say here, Advocate Mamela, this is 148.2, Advocate Mamela joined the meeting at this stage. Do the minutes reflect that? Do the minutes reflect the basis upon which she joined the meeting? Was she invited by anybody in that meeting? Did she come on her own?
No, Chair, it is not clear to me whether she was invited. The minutes, we'll have to refer back to the minutes if you allow.
Yes.
Chair, perhaps I can refer you to the minutes just
Yes,
before we
yes,
adjourn.
yeah.
It's in DD 22F. At page 2245.
Okay. Two 225, you said?
2245.
2245.
In
You want him to repeat the bundle number?
DD 22F.
Do you not have that page?
2245.
2245. Bring here.
I think it's E.
Sorry, Chair. Sorry, Chair. It's It must be DD22E. My apologies for that.
Yes.
Yes. 2245, and if you look in the minutes, 3 lines down in the table, it says NM joined the meeting.
That's the third column, or horizontal column, is that right?
Yes.
The
Yes,
third row, yeah.
Chairperson.
Yes. So, and that NM would refer to Miss known as Memela. So she wasn't at the meeting when it started, but joined it when it was in progress. Would that be your understanding, Mr. Human, as well?
Chairperson, in the present column, it just indicates present. It's unclear to me when, at what stage of the meeting the advocate joined the meeting.
Yes, well, it seems to me that if she was there from the beginning, there would have been no need for them to say she joined, if she was there from the beginning. So it must be that she joined when the meeting was in progress. Yes.
That would be a fair comment, Chairperson.
Yes.
Chair, perhaps I can just read into the record what the
Yes.
minutes reflect.
Yes.
NM joined the meeting to emphasize the urgency on completing this project and to give guidance where necessary. She also stated that the board will be sitting this week and a submission needs to be ready by Tuesday, open brackets, 26/4/2016, close brackets, to be tabled at the board meeting.
Yes, thank you.
Thank you, Chair.
Okay. We'll take the lunch adjournment at this stage, and we will resume at 2:05. We adjourn.